What are the courses in that college? I'll start again. So good afternoon, all of you. So here I'm starting with the today's topic, prospectus. Before I get into the prospectus, let us know what is prospectus. See, in our previous class, we discussed about incorporation of a company. So a company, when it receives a certificate of incorporation, will need to go has to raise their capital. The next step is raising their capital, means the finance, providing for finance to the to start their business. Generally, private limited company raises capital among the members itself, but the public limited company go for raising their capital from the public. So in order to raise their capital from the public, it invites the public through this document called prospectus. So a company which needs to raise the capital, because the capital or the finance is the lifeblood of any company, so without that cannot run. So it and a public company, when raising their money from the public, they need to provide the necessary information to the public about the company. So a document through which a company invites the public to subscribe their shares or debentures, we call it as uh, prospectus. If you look into the definition of prospectus, a prospectus, as per the Companies Act 2013, Section 2 of 7, subsection 70, prospectus is defined as any document that is described or issued as a prospectus and include any notice, circular, advertisement, or other document inviting deposits from the public for the subscription or purchase of any shares in or debentures of a body corporate. So, what does it mean? A company which invites the public, a company which invites the public to subscribe its shares or debentures, okay, shares or debentures in the form of an advertisement or a notice or a circular, through an advertisement, through a notice, through a circular, or in any other through any other document. When a company invites the public to subscribe for its shares or debentures, then that such document is said to be a prospectus. So to be a prospectus document, in order to call a prospectus, must satisfy these following. A prospectus must be in writing. It should be like an invitation to the public made by the company. This invitation is to subscribe for the shares or debentures of the company issued by the company, and must this prospectus must be dated at the date on which the prospectus is issued, and okay, and when it is date issued, in the sense published for invitation. And also this prospectus has to be signed by the concerned directors of the company. So a document which fulfills these all conditions, we can call it as a prospectus. I'll repeat it. A prospectus must be in writing. It should be in a form of invitation to the public. It must be invitation, the form of invitation requiring this invitation to public to subscribe for the shares or debentures of the company. It must be dated, or the date of the issue of prospectus must be there, and also the directors concerned to the issue of prospectus must sign the document. Okay, these are the necessary things to be conditions to be observed to call a document as a prospectus. Now look at the contents of prospectus. So this prospectus, what are the details a company provide to the public? Because this is the document through which investor takes the decision whether to invest in that company or not. So a prospectus is supposed to be fair and true enough. Okay, so let us see what are the document contents. You before I explain this, you people can guess. See, you also might have come across of various types of prospectus from various companies. Let's take an example of your college. When you are seeking an admission in any college, you might have received a prospectus of that college. Like that college may give you, this is our prospectus. So what you look into that? So why you expect a prospectus from the college? So that in the information relating to the college, everything that you need will be provided then, and you believe that it provides a true and fair information to take the admission. So generally what it contains, recall the prospectus of a college that you have received, and generally it highlights its name and the location of the college. And then what else? Anyone please? You can give the answers in chat box. Right? Please, no one? No one is ready to respond? Yeah. Generally, like name, details, the courses that the college is having, and eligibility conditions, fees, examination pattern, then the academic year of that each course, duration of the course, faculty, chairman, director of the college, principal of the college, all these. Same way, like relating to a college, how a company, the college gives all the details required to a student. Same way, a prospectus through its document, a company through its prospectus gives all the details as required and expected by the investor in order to invest or subscribe the shares of a company. So let us look into those contents in detail. The inside under this content, the details of will change from company to company. These are the major contents for any company to be provided in this prospectus. So address of the registered of the company, name and address of a registered office of the company, the name and address of the company secretary, auditors, legal advisors, and other persons as prescribed. Then the date of opening and closing of issue means in this, when company is opening its shares for subscription, and what is the last date for the subscription. Okay. Then name and address of the underwriters. Here you should know who are these underwriters. Let me go back to this term underwriters. Underwriters are the people who give the guarantee of buying the shares of a company when a company is not able to mobilize a minimum subscription. Yes, children. Who issues the prospectus? Public limited company. Public limited company issue the prospectus after issue of certificate of incorporation before commencement of business. Okay. So because after receiving the certificate of incorporation, this public limited company has to raise their capital. Okay, only after raising the minimum subscription within 180 days of issue of prospectus of a company raise the minimum subscription, then only it is permitted to go for commencement of business certificate. Remember, so if not raise the minimum subscription, then a company has to wind up before starting the business only. So in order to avoid such situation, companies generally will go to these underwriters. Who are these underwriters? Underwriters are the people or the business entity which gives guarantee of buying the shares of a company in absence of raising a minimum subscription. Okay, if a company failed to raise its minimum subscription within that 180 days of the issue of prospectus, then these underwriters will come forward to buy the company shares to the extent of minimum subscription, so that company will not go for winding up. Okay. So who are those underwriters? That their names and addresses also has to be given, and what extent these underwriters are given guarantee to buy the shares of a company. That details also to be given in the company's prospectus. Next one, procedure and time of allotment of shares. Yes, a company should also mention how it is going to allot the shares to the investors. What is the procedure it is following, and when it is going to make the allotment. See, in colleges they'll give what is the procedure for selection of a student and what is the last date for a first list. Same way, company here has to give the details what procedure is following to allot the shares and which date it is going to make the allotment. Next, capital structure of the company, like what is its capital, what is issued capital, then how much capital is going to issue, what are the types of shares, all these details are supposed to be given, like in colleges fee structure. Next, business of the company. Yes, nature of business, what type of business the company is involving. Okay. Like in college prospectus, different types of courses. It's a business management B school or management school or a normal school, like that. Business of a company, what type of business is undertaking. Then minimum subscription. Again, you need to understand what minimum subscription. A minimum subscription is that a company need to, whatever the preliminary expenses it spent at the time of promotion of a company, that amount is a minimum amount which is supposed to be raised by the company at the time of issue of prospectus before commencement of the business. Okay. Okay. Minimum subscription, generally, as just now I mentioned, a company need to raise minimum subscription within 180 days of a commencement of business. If not, if not raised, okay, not raised, company need to go wind up. Okay, so whatever funds it raised before the commencement of business or to start the business at the time of promotion of a company, those all are supposed to be collected. The minimum amount out of its total issued amount has to be collected. Generally, if a company issued 100 rupees, it need to collect at least 90 rupees of amount from the public in the form of subscriptions. Okay. Uh, the next one is, so what is that amount to be raised? That also has to be given in the details of company. The next, reports audited by the auditors of the company with respect to its profits and losses, assets and liabilities. If it is an existing company, generally, if it is an existing company, relating to the existing company, whatever financial statements are there for previous years, audited reports of those financial statements are supposed to be provided by the company. A new company, no need. Okay. Next, experts' opinion obtained, if any. Yeah. In case generally, if you see what various, in case of colleges, they used to mention so and so magazines ranked our colleges or UGC rank or okay, like that NAC rank, like that they used to give the ranking. Same way for companies, experts' opinion or rankings, if any, that also supposed to be given. The next, consent of directors to the issue. At the time of issue of document, these shares, what is the consent of directors? How many shares the directors are agreed to buy from the company? Okay, because what are their written consent? Yes, because directors, being a director of the company, he is supposed to purchase the shares of company, right? So they also a written consent of the directors. How many directors are given written consent and how many number of shares they are going to buy, this also has to be given the details in the prospectus. Next, any matters of issue which are in litigation. If a company has any litigations, any legal disputes or legal issues, that also has to be mentioned in the prospectus. Again, it is mostly in case of existing, new also. New, like if any legal formalities left over still to be taken care, then those all litigations relating to the legal matters also will be specified in the prospectus. Next, details of the directors, proposed directors, whole-time directors. I mentioned in the beginning only the details of the people involved, the directors or the chairmen, whoever are there, their details along with their names, resignations, and addresses are supposed to be given in the prospectus. Transfer and transmission of shares. Again, here, what are the rights of shareholders to transfer their shares, and also what are the rights when a transfer shares can be transmitted from one form to the other form. Then next, dividend. These details are dividends on shares. Again, the other content in the prospectus is dividends on shares. Means a company should specify the dividend policies relating to the different shareholders. Okay, when company is going to issue the dividends, and what basis is going to allot the dividends to the shareholders, what are the what is its dividend policy. These details are supposed to be provided at the dividends of shares. Next, particulars of the risk factors specific to the project. In relating to the business, any risk factors are there that also to be mentioned. Declaration by an expert, nothing to, yes, sorry. Finally, an expert also should give a declaration that the contents provided, the details or the information provided in the prospectus are as per the Companies Act only. There is no contrary. That also, if anything proved contrary, that are legally, lawfully for other laws and force, there's a give a certificate, a declaration. An expert or the concerned authentic person should give a declaration that all the formalities and all the details in the prospectus are provided as per the Companies Act and other laws in force. If anything proved wrong, they will be held responsible. That declaration also has to be given in the prospectus. So these are the contents of prospectus, which, so altogether a prospectus supposed to be true and fair, because based on which investor takes the decision to join or not, to invest or not to invest. So now the next one is regulatory authority of prospectus. Yes, Companies Act provides that issue of securities of the listed companies administered by the SEBI. That is, prospectus means issuing the shares or securities to the public. So generally, issue of securities are the rules and regulations or the regular controlling authority in case of securities is in the hands of SEBI. So as that, here also the issue of securities of any company are regulated under the guidance of SEBI, that is Securities Exchange Board of India. Now let us see the misstatements in prospectus and their consequences. Just now, every time I'm talking about the prospectus, I said it is a document based on which a investor will take the decision to invest or not to invest. So it has to provide a true and fair information in the document. So if in case, okay, madam, we say, but how far, to what extent we trust the companies give the true and fair information in their document, in their prospectus? That's the question generally raises, right? Yes, if they don't give the true and fair information, any misstatements are provided in the prospectus, then they need to face the consequences. Let us see what are the consequences, legal consequences they face in case they give the wrong information or misstatement in the prospectus. Yes. First, before getting into that, when we say a prospectus is misstatement, providing a misstatement, in order to say a prospectus contains a misstatement, it should consider it states wrong statements, or it omits or conceals any material facts in publishing. Then we say that the prospectus is having a misstatement. Okay. In case if any prospectus, if any company gives such misstatements, wrong information, or omits or conceals any information, material facts related information in the prospectus, then the company has to face the consequences in two forms. One, civil liability, the other one is criminal liability. Let us see about these consequences and the result. Yes, in case civil liability, and here again relating to the misconcepts of prospectus, there is a case given, the golden rule of prospectus, which we can understand for framing the prospectus laid down in the case New Brunswick and Canada Railway and Land Company versus McGee Ridge. In this case, the court has laid down the golden rule of prospectus. Okay, because generally prospectus means any company, it's like a window through which an investor can look into the soundness of a company's ventures, and he will take the decision whether to invest or not in the company. Opinion, he will come to an opinion, final opinion. Okay, so in order to raise the finance, a company generally raises capital, and through the public company, they issue their capital, raise their capital through issue of shares and debentures from the public. So it is prohibited from making any invitation to the public to subscribe for any shares or debentures if a company fails to provide a correct information. Okay, private companies will not go for, so there is no question of prospectus. Now, what is this case? In this case, the court has declared the golden rule. I'll show you one video. Please. Golden rules in prospectus. The golden rules in prospectus has a meaning and moral in it, which says whatever information comes from the company to the public through the medium of prospectus must be true, fair, and accurate. Accurate information in the sense, what does it mean by accurate information? A company issues a prospectus to attract the general public to purchase its securities. Interested people rely on the information presented in it, and on the basis of which they desire and take further steps to make an investment in the securities of the company issuing prospectus. So it need to provide an accurate information, correct information. True in a strict sense. True in the sense, the prospectus needs to be true in a very true in a sense, true, very strictly. Information has main objects of the issue or minimum subscription. Why company wants to issue or go for issue of shares? What is its minimum subscription? What are its allotment procedure? The schedule of allotment. Okay, like the procedure for allotment of securities, its capital structure, and its if it is an existing company, its financial statements, and if it is having any details of litigation, those details, details of promoters and their key role in the management of the business, and any defaults in payment of dues, any transactions or risk factors, all these details have to be provided by the company in its prospectus. You should not skip any of the information. Omission of information. Again, a company should not omit any information that is required for the public to take the decisions. Like additionally, it is also expected from the company to not to miss out or omit any important facts required to be presented in the prospectus. All endeavors must be made to disclose all the essential information in the prospectus as may be necessary. Honesty in presentation is the person or the persons who are presenting the information through the prospectus on behalf of the company must be honest and enough to present the facts. They should not be biased to the company. Who wrote this golden rule? This golden rule or golden legacy for framing a prospectus was laid by a justice called Kindersley. Kindersley in New Brunswick and Canada Railway and Land Company versus Muggeridge. In this case, the justice has laid the golden rule relating to the prospectus. The Richard Thorne Kindersley was a lawyer and judge. He was born at Madras. We don't need to give these details. What is a rule? He observed that those who issue a prospectus holding out to the public the great advantages which will accrue to persons who will take shares in a proposed undertaking and inviting them to take shares on the faith of the representations therein contained are bound to state everything with strict and so he says a company which invites the public through prospectus to invest proposed undertaking, inviting them to take their shares. That means they should represent all the details, everything with the strict and accuracy, and not only abstain from stating the facts, that which is not so, but omit no one fact within their knowledge, existence of which might in many degree affect the nature or extent. You need not to write all the definition. Overall, whatever in the first 2 slides we have seen, that you can write like a, okay? That you can write in simple. So here, these guys, same thing I showed you there also. They are supposed to be true and fair. The next one is civil liability. So altogether, this golden rule of prospectus says a company should provide true, fair, and accurate information and should not omit any information, material facts relating to the company when it is inviting the public to invest in it. Okay. So with this golden rule, benefit, the shareholders get benefit in making good and loss that they suffer because of untrue statements in the prospectus. Okay, this supports them in facing any misstatements. They can proceed legally. Now the next, so civil liability. What kind of for which misstatements? A company which misstatements comes under civil liabilities. A person who has been misled on the faith of misstatements in the prospectus has remedies against the company, directors, promoters, and experts. If a person who feels the prospectus has been misled him, the information in the prospectus has misled, he can file a suit against the company, directors, promoters, and experts together. Okay, he can file suit against company, excuse me, and also against the directors, promoters, and experts. So towards company, let us see who, if a shareholder who intends to buy the shares on the basis of untrue statements in the prospectus, he can file a suit against company in 2 ways: rescission of the contract, damages for decide. Okay, so let us see what does that mean. Rescission of the contract means if he purchased, say for example, X, a person who purchased the shares of a company based on the wrong information provided in the prospectus, means he don't know, he trusted the information in the prospectus and purchased the shares. Later he came to know that the wrong, then he can apply to the court for rescission of contract. Means he will hand out. Means he will return the shares. And the siding means void contract means he's not going to continue, and saying that company has misused him. In simple say 420 Act. Okay, recession within a reasonable time, but when he can go for recession of the contract within the reasonable time, the moment he knows that he has been misled with the misstatement, immediately he should proceed the company court. And before a company get into the liquidation, before company gets into liquidation, he should go for a rescission of contract. Okay, and it has certain and not only that, rescinding contract means what? He has to surrender his shares to the company and get back his money paid by him to the company. Rescission of contract means, I'll repeat once again, under the civil liability, the shareholder who proves that he has been misled with the misstatements in the prospectus has two opportunities. He can file suit against company, and he can file suit against the company directors, promoters, and experts. Against the company, if you see, again, two methods he have. Means he can the remedies against the company means how can he file, what remedies he can take against the company. Again, those are two. One, rescission of the contract. Other is damages were decided. Rescission of the contract means what? If he purchase the shares believing that the statement is true in the prospectus, but later it is proved a wrong statement, then he can apply to the court for rescission of contract. Means what? Under this rescinding the contract, he will hand over the shares that he purchased to the company, and he can demand his money back from the company along with the interest. That is what called rescission of the contract. Okay, what is the rescission of contract? He can hand over means he surrendered the shares that he purchased from the company and demand the company to pay what you call his money back, and money back along with the interest. Demand the company to pay his money back along with the interest. Okay, that's the rescission. But when he should do it before the company get into liquidation. At the same time, to file a rescission of a contract against the company, there are two conditions for the shareholder. One is statement must be material misrepresentation of facts. Whatever he just cannot go just for the small reasons. He should able to prove whatever the statement is given in the prospectus is misrepresenting the facts, then only he can file a suit. Okay, under this he can file a suit. Okay, not from his opinion. Again, relating to that, we have a Greenwood versus Leather Shoe Wheel Company case. I tried to find this case in the corporate cases. I did not find. If I get, I'll come back with that. And generally, it is a company which manufactures leather ties and issued a prospectus stating that orders have already been received. But in fact, means in this prospectus, in order to attract it customers, investors, it mentioned already been received. Means generally, what you think? Acha, orders received means maybe the company has good name and many people are coming. So let me also invest in that company. So that is one. Okay, then when I when I came to know that information is wrong, I can file the case against the company saying that misstatement. But when I can do that, that I have been deceived by the company before company gets the orders, or before company gets into liquidation. then only I can go for filing a suit against the company. See the same thing here. Like in order were only on trial orders, no consumer has not expressed any desire to buy. So we can say this. They mentioned it as already received, but they did not receive any orders. Then it is a misleading. So because of which I purchased the shares as a investor. So then I can file a suit against the company for the reason of misstatement. But when should I take that? He did not rely on the statement. He is not deciding the contract. But he should show before that, again, he should not try to sell the shares of the company. So in LOT, and he must have relied on the prospectus. But if a person purchases shares in open market, he has no right to company. Okay. So he has, if he proves that he has been deceived by the company at the time of allotment, then he can go for a filing a case against the company. But if you purchase in the open market, means you knowing that you purchase, so you are not liable. You cannot file a suit against the company. These are the conditions. The next one is affirmation. Means a shareholder, excuse me, a shareholder also loses his right of rescission against company in case of affirmation. Affirmation means if he try to sell the shares, means you said company deceived you. But before company, the court take the action, or before you entering into action, even after knowing that company has deceived, you try to sell your shares, or you try to transfer your shares. Okay, or you paid the call money whenever company made a calls. In all this, that means you also indirectly trying to deceive others, or you accepted for the whatever the misstatement given in the company prospectus. In such case, also a shareholder cannot go for a right of rescission. Okay, I'll repeat. Attempt to do affirmation. In case of affirmation, a shareholder loses the right of rescission against the company. That means he cannot surrender his shares and get back his money. When if he tried to sell the shares, or if he transfer the shares, or if he pay the cost when on shares, or receive the dividend on the shares, he is not having a right. Next one is unreasonable delay. Yes, a shareholder, see, if you identify that the company has deceived you, and but you did not taken the necessary action within the 15 days, then also your shareholder loses the rescission right of rescission. Shareholder fails to resign within a reasonable time, he loses the right. Means within 15 days, you should be able to identify from the data. What 15 days is not given clearly here, but 15 days of time is taken as too long. Beyond 15 days, if you go, the shareholder will lose the winding up. As we said already here in the beginning, before liquidation of the company. So a shareholder, if want to exercise his right, he should go before the winding up of a company, but not at the time of winding up of a company, or after winding up proceedings have been taken, he loses his right. So these are the conditions when a shareholder loses his right to rescission or against company. So first, let us see once again. Rescission of the contract means a person, like a shareholder, can surrender his shares to the company and get back his money along with the interest. That is called rescission against the country. When he can do, when he proves that he purchased the shares of company with a faith that a prospectus has provided the correct information, but later identifies that there is a misstatement, he can exercise this. Okay, but before company get into liquidation. But in order to exercise this right, there are certain conditions when he can exercise and when he cannot exercise. Okay, he should able to prove that statement must be material misrepresentation of facts. The second thing, in case of affirmation, that means he cannot exercise. That is, if he is trying to sell the shares or execute the transfer of shares or pay the calls or dividend amount received, or if he takes a undue delay, that's beyond the 15 days of time, or at the time of once the proceedings for liquidation are started. Under these conditions, he cannot go for rescission of against court company. What is the next remedy that the shareholder has? Damages for decide. This is the next remedy. Damages for decide in case shareholder who's against the company he can take. What is that? The shareholder who is induced by misstatement is entitled to sue the company for damages. He cannot retain the shares and claim damages against the company. Okay, means see, if you feel that you have been induced by the company by wrong information or wrong statements, then if you are able to prove that misstatements are relating to the facts, then shareholder can file a case against the company for claiming damages. When he is claiming damages for the deceiving by the company, he cannot hold the shares. He has to surrender the shares and he should claim the damage against the company. That how much he can claim depending on the damage caused to him, that decided by his lawyer and the court. The next one is remedies against the directors, promoters, and experts. Yes, shareholder has two remedies when you misstatements in prospectus are given. One is against the company, the other one is against the directors, promoters, and experts. So against the company, we just have to again against company has two. One, rescission against rescission of a contract and damages for decide. So these are we discussed. Now remedies against the directors. Yes, any wrong information or misstatement provided in the prospectus liables the directors, promoters, or any other persons who authorize the issue of prospectus. Because in the prospectus contents, we learned the directors, promoters, and the authorized people who are involved in the preparation of the prospectus should also sign. That means they are the persons responsible for any misstatements in the prospectus. Means, right? So these people will be held responsible for any. To what extent? For any loss, support reasons, and truth statement. However, they are not liable if they provide the following defenses. They will be liable, but if they provide the information is wrong, means if they prove these points, what are those points? Prospectus issued without their consent, if they are ignorant of untrue statements in the prospectus, if they have reasonable grounds to believe that statements were true and daily honestly believed to be true, in these grounds, they'll not be liable. If they fail to prove any of this, they'll be held liable. Okay. The next type is that basically what we said here. Misstatements, consequences are two types: civil liability, criminal liability. So we have discussed under the civil liability till now. Now the criminal liability. If you look into the criminal liability is that if every person in the involved in the issue of prospectus is liable and punishable. What punishment they'll get? The imprisonment for 6 to 10 years, depending on the misstatement they provided, and also fine. Okay, these two depends both. Sometimes only fine, sometimes only imprisonment, sometimes both. Fine, some liable to a fine and liable to imprisonment. What is the extent of fine they'll get? Less than the amount involved in the fraud. Whatever the fraud they made 6 times, not less than the fine, which shall not be less than the amount involved in the fraud, or may extend 3 times the amount involved in the fraud. Okay, so I'll repeat. So criminal liability, if it contains any untrue statement, then the people involved in the prospectus, the authorized in the issue of prospectus will be liable to what is their liability? Fine and imprisonment. Sometimes both. Fine, what extent? Fine is to the extent of the fraud they caused, or sometimes the maximum of 3 times the actual fraud amount. The punishment, imprisonment is for 6 months to 10 years, depending on the fraud they caused. If they prove such statements are immaterial and reasonable grounds to believe, then they are not liable. That is about criminal liability. Now coming to the next important one is this from the examination point of view. Just a moment. Statement in lieu of prospectus. What is statement in lieu of prospectus means? Statement in lieu of prospectus means, and generally, who issue the prospectus? Public limited companies, right? So when do they issue the prospectus? At the time of raising a capital, in order to raise their capital or funds. Okay, but from public. But generally, if in any case, if a public limited company wants to raise their capital from the private sources instead of from the public, then they need not to issue any prospectus. But instead of the prospectus, they are supposed to issue a statement which is called statement in lieu of prospectus, means statement in the place of prospectus. Okay, so I'll repeat once again. What is statement in lieu of prospectus? A statement which is issued in the place of prospectus is statement in lieu of prospectus. Who issue? Public limited company. When issue? When it go for raising its capital from the private sources. Okay. Generally, public company issue the prospectus to raise their capital from the public. But if they want to raise their capital from their private sources, they go for they need not issue the prospectus. Instead, they go for a issue of statement in lieu of prospectus. Okay, this statement should also contain all the information and they should disclose everything that what they give in the prospectus, as it is like a prospectus, but they'll not issue the prospectus. And this document, this statement has to be issued at least 3 days before the allotment of shares and must be registered with the registrar. Okay, and the person has to sign and must issue at least 3 days before the allotment of the shares. After this, issue of prospectus and raising of capital. Once a public limited company raise its capital from the public and raise its minimum subscription from the public, then it go for getting one more certificate called certificate of commencement of business. So what does it mean by certificate of commencement of business? Means a certificate which is issued by registrar to the public limited companies after fulfilling all the formalities with the necessary documents is said to be certificate of commencement of business. And what are the documents to be submitted? Generally, what we said, a private company can start its business immediately after receiving the certificate of incorporation. But public company has to go for one more certificate, that is called certificate of commencement of business. Okay, so to get this certificate, first is need to raise their capital. Once the capital is raised, then they go for a certificate of commencement of business. And for this certificate, they need to submit 3 documents. One, that the minimum subscription has been raised, a document proving that minimum subscription has been raised. The second document, that the shares of company has been purchased by the directors. In incorporation time, written consent of directors to purchase the shares, that document they will submit. So whoever given a written consent to purchase the shares of company, those directors again here a written consent that they purchased the purchased and paid for the shares of the company. That has to be submitted. And the third document saying that all the formalities required for the commencement of business as per the Companies Act have been followed and uh, observed, proving that a signature with the concerned persons. These three documents has to be submitted to the registrar of companies. Then the registrar of company will verify these accuracy of these documents, authenticity of documents, and will issue a certificate called certificate of commencement of business. Once this certificate is issued, uh, a public limited company can start its business, can enter into the contracts. If any company fails to get this certificate and start their business, that company is liable for a penalty of rupees 50,000. Understood? Then that's about uh, prospectus. Okay. Here, about the prospectus, the important aspects are for long answers. One, what is prospectus and what are the contents of the prospectus? Two, prospectus is a document which everyone understand. I want a reply from you all. Everyone has understood this topic, today's topic. So misstatements, if any, one proves that the statements given in the prospectus are wrong, then they can go for claiming against company faces consequences from the shareholder. That is civil liability under civil liability and other under criminal liability. Under civil liability, again you have two, that is remedies against company and remedies against directors. Under the remedies against company, again a shareholder has two rights: rescission of the contract and claim for damages for decide. Okay. Again, in order to avail this right of rescission of the contract, a shareholder can avail the right only under certain conditions. After that, the next one is criminal liability. If any information is untrue, untrue statement provided, then the directors, the people concerned, will face the criminal liability to the punishable either that is imprisonment and fine. After that, short answer you can expect golden rule of prospectus, the golden rule of prospectus, and the commencement of business. Sorry, certificate of commencement of business. These you can expect a statement in lieu of prospectus also. Statement in lieu of prospectus, certificate of commencement of business, the golden rule of prospectus. These you can expect under short answers. Yes. Do you have any more doubts? Anyone, please? Okay, thank you. In next class, we'll meet with the other topic, some other topic. That is prospectus over company learner directors. So, directors of company and their powers. So thank you, children. Thank you for being here.